Trump sues his own government for $10 billion. What is really happening? When a president sues his own government, America's constitutional machinery is not merely evaluated, it is repurposed. On January 29, 2026, Donald Trump, accompanied by his sons and the Trump Organization, filed a lawsuit against the United States Department of the Treasury and the Internal Revenue Service, demanding no less than $10 billion in damages. The allegation: unlawful disclosure of tax records that inflicted reputational and financial harm. By April, reports suggested that the president might seek a settlement. At one level, the case is legible as a dispute about privacy, bureaucratic failure, and institutional accountability. At another, it is something rarer, a sitting president litigating against the executive apparatus he commands. It is not a constitutional impossibility. But it is a constitutional curiosity, one that illuminates the evolving relationship between the American state and those who wield it. The episode offers a window into a deeper transformation. The United States has long prided itself on a system of dispersed authority, anchored in the logic of the United States Constitution: ambition counteracting ambition, branches checking branches, offices restraining occupants. What happens when the occupant uses the system not merely as an arena, but as an instrument, one that can be bent, contested, and redeployed for personal, political, and strategic ends? The architecture of paradox. The lawsuit appears to collapse into a paradox. How can a president sue his own administration? Yet the American state was never designed as a seamless hierarchy. It is, instead, a lattice of semi-autonomous actors, bound by law but often separated by function, mandate, and culture. The IRS, though formally subordinate to the Treasury, operates with significant procedural independence. The Department of Justice, which would ordinarily represent the government in court, retains its own institutional norms. Federal courts stand apart still, insulated, at least in theory, from executive pressure. Within this architecture, it is conceivable for one node to clash with another, even if both trace back to the same constitutional root. Thus, the lawsuit is not a legal contradiction so much as a political anomaly. It is an instance of intra-executive conflict externalized through judicial means, a phenomenon more common in fragmented or transitional regimes than in stable presidential systems. What makes this case striking is not its formal possibility, but its symbolic inversion. The president, rather than arbitrating disputes within the executive branch, becomes a litigant against it. Authority is no longer exercised from above, it is asserted from within, litigation as strategy. To understand the lawsuit, one must look beyond its legal merits. The $10 billion figure is a less precise calculation than a strategic signal. The aim is unlikely to be a courtroom victory in the conventional sense. Rather, the lawsuit functions as a multipurpose instrument. First, it reframes the narrative. For years, Trump's tax affairs have been the subject of scrutiny and controversy. By alleging unlawful disclosure, he shifts the locus of wrongdoing from himself to the state. The defendant becomes the accuser, the investigated becomes the injured party. In political terms, this is an inversion of roles that transforms vulnerability into agency. Second, it creates leverage. High-stakes litigation can compel negotiation. Even if the claim is legally tenuous, the cost financial, institutional, and reputational, of prolonged proceedings may incentivize settlement. A negotiated resolution could limit further disclosures, shape public perception, and provide a form of vindication without the uncertainties of trial. Third, it evaluates institutional boundaries. By initiating such a case, the president probes how far the system can be stretched. Will the courts entertain the claim? Will the Justice Department defend the agencies with full vigor? Will Congress intervene? Each response reveals something about the elasticity of American governance. In this sense, the lawsuit is not merely reactive, it is exploratory. It is an experiment in the use of law as political technology, the blurring of public and private. The American presidency has always contained a tension between office and individual. The office is public, constrained, and impersonal, the individual is private, ambitious, and self-interested. Ordinarily, the two are separated by norms, conventions, and legal safeguards. This case erodes that boundary. Trump is not suing as president per se, but as a private individual and business leader. Yet his status as president is inseparable from the act. The authority of his office shadows the litigation. Even if it is not formally invoked, the result is a hybridization of roles. The president becomes both sovereign and subject, arbiter and litigant. The state, in turn, becomes both defendant and instrument. This fusion complicates the notion of impartial governance. If the head of state can deploy legal mechanisms to pursue personal grievances against the state itself, the distinction between public duty and private interest grows increasingly tenuous. Such dynamics are not unique to America. In many systems, leaders have used legal processes to consolidate power, protect assets, or neutralize opponents. What distinguishes the American case is the tension between these tendencies and a deeply entrenched constitutional tradition that resists them. The institutional response, how the system reacts, is as important as the lawsuit itself. Three actors are central: the courts, the executive bureaucracy, and the political branches. The courts must decide whether the claim has standing and merit. In doing so, they are not merely adjudicating a dispute, they are delineating the permissible scope of intragovernmental litigation. A willingness to hear the case could establish a precedent for future conflicts. A swift dismissal would reaffirm traditional boundaries. The executive bureaucracy faces a subtler challenge. Agencies such as the IRS must defend their actions without appearing politically motivated. The Justice Department must represent the government while maintaining its institutional integrity. Any perception of partiality, whether in favor of or against the president, risks undermining public trust. Congress, meanwhile, operates in the background. It may choose to investigate the alleged leak, to scrutinize the conduct of the agencies, or to use the episode as ammunition in broader partisan battles. In a polarized environment, such interventions are likely to reinforce existing divisions rather than resolve them. Together, these responses will determine whether the lawsuit remains an anomaly or becomes a precedent. The international gaze: America's domestic dramas rarely remain domestic. Allies and adversaries alike scrutinize its political system for signs of strength or weakness. From one perspective, the lawsuit may be read as evidence of dysfunction. A president at odds with his own administration suggests fragmentation at the heart of power. For strategic competitors, this could imply reduced coherence in policymaking and diminished capacity for sustained global leadership. From another perspective, the very existence of the lawsuit, and the likelihood that it will be processed through established legal channels, demonstrates resilience. Few systems would permit such a challenge to unfold openly. The capacity to absorb conflict without collapsing is a form of strength. This duality, instability on the surface, continuity beneath, is a recurring feature of American politics. It is also a source of both admiration and skepticism abroad. The settlement question: reports that Trump may seek a settlement add another layer of complexity. Settlement, in legal terms, is pragmatic. It avoids the costs and uncertainties of trial. In political terms, it is ambiguous. A settlement could be framed as vindication if it includes concessions or compensation. It could also be portrayed as avoidance if it precludes a definitive judicial rule. For the government, settlement may limit exposure and prevent the establishment of an unfavorable precedent. Yet it may also appear as capitulation. The strategic calculus on both sides is thus delicately balanced. The outcome will depend not only on legal assessments, but on political considerations, timing, public opinion, and the broader electoral context, precedent and its discontents. The most enduring consequence of the lawsuit may lie in the precedent it sets. If a sitting president can sue executive agencies for actions taken in the course of their duties, future occupants of the office may be tempted to do the same. Such a development would mark a shift in executive authority. Instead of resolving disputes internally or through political channels, presidents could resort to litigation as a routine tool. The executive branch would become not a unified entity, but a field of contestation mediated by the courts. This, in turn, would place greater strain on the judiciary. Courts would be drawn more deeply into political conflicts, asked to adjudicate matters that blur the line between law and governance. The risk is not that the courts will fail, but that they will be transformed, becoming arbiters of disputes that were once resolved elsewhere. Constitutional stress and adaptation. The American constitutional system is often described as robust. It has survived civil war, economic depression, and global conflict. Yet its resilience lies not in rigidity, but in adaptability. The Trump lawsuit can be seen as a stress test. It pushes the system into unfamiliar territory, forcing institutions to respond to scenarios that the framers did not explicitly anticipate. Whether the system emerges strengthened or weakened will depend on how these responses unfold. If the courts assert clear limits, if the executive bureaucracy maintains its independence, and if political actors exercise restraint, the episode may reinforce the underlying structure. It will be remembered as an oddity, a moment when the system was evaluated and held. If, however, boundaries blur, norms erode and precedents accumulate, the long-term effect may be more profound. The system will not collapse, but it will change. The balance between office and individual, between law and power, will shift incrementally. The deeper trend, personalization of power, at its core, the lawsuit reflects a broader trend in modern politics, the personalization of power. Leaders increasingly frame political conflicts in personal terms, casting themselves as protagonists in narratives of struggle against institutions, elites, or systems. In such narratives, the state is not a neutral arbiter but a contested terrain. Legal processes become extensions of political strategy. The distinction between governance and litigation blurs. Trump's lawsuit is an American manifestation of this trend. It is shaped by the country's unique constitutional framework, but it resonates with developments elsewhere. The question is not whether the United States will follow the same trajectory as other systems, but how its institutions will mediate the pressures of personalization. Conclusion: a system repurposed. The image of a president suing his own government is arresting. It invites caricature, a leader at war with himself, a state turned against its own head. Yet the reality is more nuanced, and more consequential. This is not simply a legal dispute. It is an instance of the American system being used in an unconventional way. The tools of law are deployed not just to resolve conflicts, but to reshape them. The boundaries of authority are not merely evaluated but renegotiated. In the end, the significance of the lawsuit lies less in its outcome than in its implications. It reveals a system that is both resilient and malleable, capable of absorbing shocks but also susceptible to gradual transformation. If there is a lesson, it is this: the strength of constitutional order is not only in its rules, but in how those rules are used. When the highest office in the land becomes both litigant and leader, the question is no longer whether the system works. It is what the system is becoming.